Thank you, Corolla. Now moving on to the homestead exemption. Just a quick history of the homestead exemption. It started in 1934 at about $5,000. The first $25,000 homestead exemption came in 1980. We'll be talking a lot more about that section Save Our Homes Amendment in 92 to 95 later on in the presentation. And then the second $25,000 came in along with a non-homestead cap of 10% and portability in 2008. And all those will be addressed in this presentation. One thing to understand about the $50,000 homestead exemption is it is banded, meaning the assessed value between 0 and 25,000 is fully exempt from property taxes if you qualify for homestead. The next 25,000 does not carry an exemption with it at all. And the second 25, making up the full 50, is for the assessed value between $50,000 and $75,000. And then above 75, there is no exemption. And that second homestead exemption in the yellow between 50 and 75,000 is not, school taxes are not exempt. So you will still pay school taxes. The only exemption available for school taxes is the first 25,000 of value. So depending on the taxing district that you live in and depending on what the millage rate is in your particular home, the exemption is approximately saves you between $500 and $1,000 a year. The higher the millage rate, the higher the closer it gets to the $1,000. However, the most important thing about the homestead exemption once you qualify is the year after you qualify, your increase of assessed value every year thereafter, as long as you maintain that as your homestead, can't exceed 3%. Actually, it's 3% or consumer price index, whichever is less. And in 2022, if you're already homesteaded in 2021, the CPI is at 3%. Actually, the actual CPI was close to 6.7%, but it's capped at 3%. So again, there's that magic January 1 date. In order to qualify for homestead, you must own and occupy on January 1st, be a permanent Florida resident, and the gating criteria for permanent Florida residents is a Florida driver's license and auto tag for the most part. You can only have one homestead per person. If you're married, both husband and wife cannot have two homesteads. You can only have one. You cannot have any other residency-based exemption on the planet. But primarily in the United States, there are exemptions in for instance, the British Virgin Islands. If you happen to own something there and you have an exemption, you will not qualify for Florida. You can always remove if you have another home, remove it in another state. If you want to qualify for Florida, and we will accept that. And also corporate entities cannot qualify for homestead. So if you're an LLC or an Inc., you cannot qualify for the homestead exemption at all.
Kevin, we have a question. Yes. Is the filing of the declaration of domicile sufficient to establish residency for the homestead exemption?
The declaration of domicile, I believe, is filed through the clerk of the court, and that is not this office's specialty. However, I believe it is for people who are trying to determine residency for schooling or even for legal purposes. It is not the same as the homestead exemption, though.
So if somebody fills that out, they still need their driver's license, yes, and tag number, yeah, a Florida tag number to.
That's
yeah,
right.
if they have a car, and if they do not drive, at least a Florida identification card, which is similar to a driver's license.
Right.
Thank you for that question. Very good one.
Someone has another question that they inherited a condo, but they are not living there yet because it's being remodeled. They did fill out a homestead exemption form after March. Now, would they qualify for the homestead exemption if they are not occupying the residency yet?
Another good question. First of all, the deed has to be in their name. If they inherited something and it's still in their relatives who they inherited from, they in effect do not own it yet. So it is very important that the deed gets in your name. Sometimes they get caught up in probate for a while, and it takes a while to get the deed in your name. We will accept an application, but until that deed gets in your name, you cannot qualify. But if you have not become a Florida resident or occupied it yet, you would not qualify for this particular year. Save our homes. So in 1992, one of our property appraisers introduced some legislation that was approved. At that time, what was happening is Florida homeowners were getting taxed out of their homes. Every year, their value went up by whatever the market value was. So he suggested, and it was approved by, once you're homesteaded, your assessed value for tax purposes can't go up by more than 3%. Actually, it's the lesser of 3% or the consumer price index. This was a very important amendment for longtime Florida homeowners, and we'll get into a little more as to what it can mean to you. For instance, if you look at the CPI over the last 13 years, it only hit 3% or above twice, in 2012 and now in 2022. So that was capped out at 3%. But the years between 2012 and 2016, for instance, your assessed value only went up by 1.7, 1.5, 0.8, 0.7. So no matter what happened to your market value, and that was a period of very high rising market values. So your taxes didn't go up much at all, which is the real benefit of having a homestead in Florida. And if you don't have a homestead in Florida, let's say you have a vacation home or you're a commercial property, your property can't go up more than 10% a year on assessed value. And you're creating a cap there as well, but that's only for non-school taxes, is that cap. You're still paying school taxes on your market value on a non-homestead cap. So here's a quick little example of what happens. Just market value year after purchase of the following year, you went up 5%, but you're capped at 3%. So there's $6,000 of value that you're not paying property taxes on, and that carries forward. But at no time can assessed value exceed just market value, and we'll get into that example as well. So over a period of years, we've done the same calculation for you. Market value increasing 5%, maximum 3% on CPI, and most times it's a lot lower than 3%. You're creating that value gap between just and assessed value, almost $44,000 by year 7, that you're not paying taxes on. Any exemptions come off the assessed value. And the difference is called the Save Our Homes benefit. And there you go, $44,000 almost. So here's that same $44,000 roughly. And that property was then sold. The new owner, let's say that paid a certain amount for that property the year after purchase. And many of you may have experienced this if you recently purchased a home in 2021. The year after your purchase, your market value equals your assessed value. That is a requirement of Florida law. It's a new owner. It automatically market equals assessed. And then you take your homestead exemption off that. So that new owner, if they bought in year 7, inherits the taxes, that's 6164 of the prior owner for that year that they bought, but the next year they are now the new owner and the homesteader, so you will see an increase in taxes. Here's a great example of the Save Our Homes cap. two identical homes, same square footage, in a very desirable neighborhood in St. Petersburg. The one on the right was bought in 1993 and has had the Save Our Homes cap since then. The one on the left was bought in 2018 in a rising market. And then if you look at the 2020 taxes differential between the two, the one on the left, $4,364 in taxes, and the one on the right, with the benefit of the Save Our Homes cap, only $678. Now, whoever comes in and buys that house on the right, for now probably a higher price than the one was bought on the left because of higher rising prices, will pay at least $4,000 and maybe even more the year after purchase. So we get a lot of questions every year when this happens. Why do I pay more than my neighbor? More than likely, it's because your neighbor has been in that home for quite some time and enjoyed the Save Our Homes cap. Again, touching on the 10% cap, it's a non-homesteaded property or a commercial property. And the cap remains as long as there is not a change in ownership. And once again, you're still paying school taxes on the full value. The 10% cap does not apply to school taxes. Any change in ownership will automatically result in a cap loss for the most part. A little example as to what could happen to your just value and assessed value over time. Maybe some of you remember the big market rise in the 02 to 06, 07 time frame. You can look at that as the first 5 years on this chart. Your assessed value was peaking, your just value was going way up in that time frame, and your assessed value is just going up by the 3% cap. And then 08 to 2012, there was a big downturn in the Florida market to where a lot of properties, the assessed value met the just market value. And again, assessed cannot exceed just market value. And now this period that we're going through right now, you can see you're building that Save Our Homes cap up again between years 6, 7, and 8. Again, you're limited by the 3% or CPI, whichever is less, no matter what happens to market value.
And we have a question, Kevin, that the Homestead and Save Our Homes cap were permanently put into law and has no expiration, correct?
That is correct.
We also have a question that
until the legislature decides they want to do something different.
Right. We also have a question, and I think one of our staff members who was on the meeting answered that this property owner has a driver's license that is in another state, but his wife has their driver's license in Florida. While their son goes to PAMS and they are residents here, their cars are registered in Florida. Since they file taxes jointly, can we combine our family as a homestead? Denisha said that the home will qualify for homestead under the spouse that is a Florida resident, assuming that they do not own any property receiving exemption in Florida or any other state.
That is absolutely correct. As long as one of you, if you are married, has a Florida driver's license and your cars are registered here, you would qualify. And no other exemption in another state. So we are now in the period where market values are rising and assessed values are creeping along and creating a bigger Save Our Homes cap for most residences here in Pinellas County and in the state of Florida for that matter. So what happens to that Save Our Homes cap if you decide you want to sell? That's where we get into portability. Yes, you can take that difference with you. So if you've been in your home for a while and decide you want to either upsize or downsize, you can, you sell your home and the the January 1 of the year you sell your home, there's a difference between just market and assessed value. Again, your Save Our Homes differential. You can take that with you to another home if you establish Homestead anywhere in the state of Florida. It does not have to be in Pinellas County. If you establish Homestead within 3 tax years of the date of sale of your home. Now that's actually 3 January 1s. So if you sell, and we'll get into that, if you sell in 2021, January 1 of 2021 is the first of the 3 tax years. Then 2022 and 2023, you would have to establish Homestead by January 1 of 2024 in order to take that Save Our Homes differential with you on the home that you sold. And again, the application for portability goes along with a Homestead application. On our online application, it will ask you, do you want to apply for port? If you had a previous Florida homestead, please, when you're online, say yes to the portability question, and we take care of the calculation for you. There's nothing else you have to do once you provided us your previous address, even if it was in another county. So there is a benefit whether you upsize or downsize. The calculation is the same, but if the new just value of your home that you bought the January 1 after you bought it, so you bought a home in 2021, you will be assigned, we will put a value on it as of January 1 of 2022. That value will be compared to your previous home that you sold, and if it's greater, you get the full value of that Save Our Homes benefit up to a maximum of $500,000. Now, if you downsize, if the new is less, you would get a prorated benefit. So let's say your new just value was $200,000 and the previous was $400,000, you would get 1/2 of that benefit that you had on the previous home transferred to your new home. Again, limited by the $500,000 max. And all of that is handled in our tax estimator. You can easily go on our website, put in your if they're both in Pinellas County, it's real easy. You put in the home you sold, the home you bought first, and the year you bought it. You put in your purchase price, and then you put in the home you sold and the year you sold it. And our tax estimator will handle that for you and give you an estimate of your portability as well as your taxes in the January 1 in the year after you bought the home. So again, it's 3 January 1s. So if you on the top of the chart here, if you sold in February 1, you truly do have 3 years. But if you sold here in December 1, you have a little over 2. It used to be only 2 January 1s. And our property appraiser, Mr. Twitty, suggested legislation, which was approved in 2019, if I'm not mistaken, or 2020.
2020.
Approved in 2020 by the voters, that added that 3rd year, which was very important because people were, let's say they sold their home and they were waiting on a newly constructed home or condo, and there were delays. A lot of people were losing their cap. They thought they would be in by the next January 1, but they weren't able to get in. But now there's a full 2 years, and that was really the intent of the law to begin with. And we're really happy that passed because very few people will miss that. Transferring their cap. Trim notice. Again, required by Florida law, every year you will get a estimate notice of proposed property taxes mailed to you at the parcel address or at your mailing address if it happens to be different than the parcel address. This is a very important document. I really want to stress this point because a lot of people don't pay attention to it because the first thing they see in the upper right corner, which is again a requirement, do not pay, this is not a bill. but it provides you a wealth of information about your property and your upcoming taxes and exemptions that will apply for the current year taxes. This will be mailed in August of 2022 and your tax bill will be generated from most of this information. So it's really important that you pay attention to this. If it's missing an exemption that you thought you had, we ask you to call our office because we can still probably get you qualified if we're missing some information. If you don't like the value, you can call us and talk to our appraisers and deal with the value as well. But this is basically provides the taxing district you're in, your mailing address, your parcel number. This section here shows last year's and this year's market assessed and taxable value. If you've owned the home for some time, again, that assessed value from year to year can only go up by the 3% or CPI, whichever's less, no matter what happens to market. This area here gives you all the millage rates related to the taxing districts to where your home is located. This happens to be in county, unincorporated county. So, but you take the taxable value, and the taxable value is always after any exemptions, multiplied by the millage rates, give you your proposed taxes. And column 3 is the most likely taxes that you will receive, for the current year once you see this. Column 2 is called a rollback rate. Column 1 just gives you what your taxes were the year before. So in this particular case, you see the taxes went from 3147 to 3207 for this particular property. We'll get into the non-ad valorem in a little bit in another section. Down below, this gives you all the exemptions that have been applied to your property for both years. And also on the left side gives you your Save Our Homes cap. How much is the difference between market value and assessed value? And then the bottom section is very important as well. If there's something that that you thought you were entitled to, or if you disagree as far as an exemption is concerned, or if you disagree with the value, first we encourage you to call our office and see if it could be worked out. But you also have the ability to file with the clerk of the court in the yellow here below what is called a petition for adjustment with the Value Adjustment Board. You as a citizen have a right to object to your value or object to the lack of us providing you an exemption, but you must file a petition on or before it's 25 days after the mailing of the trim notice. So please pay attention to that. But again, we welcome you to call our office first to get the information as to why you may or may not gotten the exemption, and we can maybe still get you qualified, or why talk to an appraiser about the value of your property. On the back, you also have the ability to attend any and all public hearings, and these are the entities which basically come up with your tax rate, which when applied to the assessed value, the taxable value of your property will result in your taxes. So all these budget meetings, there are hearings. 2 years ago, they were virtual, but last year they were virtual and in person. You could attend, you can ask the taxing authorities as to why they're either raising the rate or lowering the rate, and you have a voice there as well as a citizen. And we provide the dates, times, and phone numbers for any questions you may have. There are certain districts within the county that have what is called a non-ad valorem assessment. Typically, this relates to street lighting, stormwater, surface water, where improvements were made to that particular area, and each resident is required to pay a portion of those improvements, as typically your taxing authority has floated a bond to pay for it, and it is being paid back by these assessments. And these assessments go on for a period of time. And some are new, some have been around for a long time, but you can always see those on the tax bill of the property you're buying to make sure. And we do this as a courtesy. We do not administer these surface water, any of these assessments, non-ad assessments. We always give you a contact number that you can contact and ask what it's all about. And your exemptions, any type of exemption, does not apply to non-ad valorem taxes. Those have to be paid regardless. And then at the bottom of that page, we give you the explanation of market value, assessed value, taxable value. And then again, column 3 on the previous page is the most likely taxes you will be paying for the current year. And then some definitions of all the things we've touched on: market assessed, taxable, 10% cap, et cetera, and you can always get a lot more information by visiting our website. We also publish a trim guide every year that gives you a lot more detailed information with regard to this trim notice. Wrapping up our final section here, and then I will open it up for any and all questions that you have. On our website, we offer some tips for anybody buying a home or selling a home. These are very valuable pieces of information that explain what happens to your taxes the year after you buy. When you're selling, it explains portability and what you can take with you if you're buying another home. These are all useful tips and facts for you to take a look at anytime on our website. We wanted to give a pitch here for the clerk of the court. This is a great service, as if a property changes hands, a deed is recorded, and its deed is recorded at the clerk of the court. This service allows you to sign up for it for free, mypinellasclerk.org, and anything that is recorded at the clerk's office with regard to your name or something very similar to your name, you will get an alert. So you can always keep monitoring something that is recorded in your name. Or, for instance, a permit requires a notice of commencement, which is over a certain dollar amount. If you recently are doing some improvements to your home and a permit is filed, a notice of commencement will be filed. You'll get an alert that it was filed in your name. I registered for this service. My middle initial is J. I'm Kevin J. McKeon. I've gotten alerts when it's Kevin P. McKeon. So at least I can go in and see my name, my property, and make sure that there's nothing being filed erroneously against my property. Very valuable service, and again, I encourage you to do it. It's free. And we'd like you to follow us anyway. We have now. How long ago was that, Johnny? We're on Facebook.
Past 2 months.
The last 2 months, we've joined Facebook, so we provide updates and information. We have e-newsletters tailored for homeowners, real estate professionals, and business owners. You have the ability to sign up on our website, and obviously attend one of our public sessions, which you're doing today. We look forward to the day where we can do it in person as well as virtually. So upcoming programs, you will always see them posted on our website. Please look out for those if you're interested. We'd love you to join, and they will be every month. We will provide a new update.
That's right. Our next session is going to be on March 10th, and we encourage anyone who owns a business or operates a business to attend that session on March 10th. We'll go over a lot of the different processes that businesses will have to go through in filing for their tangible property. Again, as Kevin mentioned, please visit our website at pcpao.org for more information about any public education or outreach initiatives that we have. And if you have any specific questions about your property, you certainly can call us at 727-464-3207. We have friendly representatives, and you rarely have to wait on hold. You can speak to somebody right away. And of course, we are open in 4 different locations throughout the county on business hours, Monday through Friday from 8 to 5 p.m. Property owners will also be receiving a piece of mail this week. For those who have exemptions, you may be on the lookout for this receipt of your 2022 tax exemption renewal. For many people, this is simply just a receipt to let you know, and if there are no changes, you can simply file it in your records. If you do have changes to your exemption or any circumstance, there are some instructions on the document. We encourage you to take a look, follow the instructions, and give us a call and respond to the notice.
Yes, again, this is an important document if there are changes, this is voluntary on our office's part. We like to remind people of the exemptions that they currently have on their property, and if they feel that they're entitled to others, we give them the opportunity. And let me scroll down here at the bottom. If there are changes, one of the biggest changes that we get is someone gets married, and if people don't pay attention to this and the married couple keeps 2 homesteads into the next year or beyond, it could result in a lien on one of the properties. So we give you the opportunity every year. If you got married in the previous year and you still have a homestead on one of your properties in 2022, on both of your properties, you need to remove one. And it is your choice. Obviously, you want to remove the one you're not living in, but it depends on which one you're living in. You need to let us know. If you got a divorce, if there was a death of one of the exemption holders on the property, we need to know. And then on the reverse side, so your signature, you can send this into our office. We'll make the changes, or just call us if there is something that concerns you. If there's maybe an exemption that you think you qualify for, like the senior exemption. I'm 65 and my adjusted gross income. We send an application to you. We know when you turn 65, because if you are, and these only go to homesteaders. So we know when you turn 65, we will send you an application, and you should receive, these were mailed today. You should receive it either tomorrow, Saturday, or Monday. And again, if there are no changes, it's just a receipt that you have homestead for 2022, including those who have already been approved for 2022, who may be brand new homesteaders. We may have missed you when we created this file if we recently approved your homestead, but feel free to call our office or even look online. If you go to your property online, if you've been approved for homestead for 2022, it will indicate in a yes and highlighted green. So you can rest assured that your homestead exemption has been approved. Again, filing deadline is March 1st. One thing I do want to point out, if you have not filed for homestead, if you do not yet have your Florida driver's license, our online application will not take your homestead application. There's a reason for that. Our online application, when you go through it and you have a Florida driver's license tag, we go to the DMV while you're applying and verify your social, date of birth, and your driver's license. So it makes it easier and quicker for us to approve your application. You can come to our offices and apply even if you don't yet have a Florida driver's license, and you may have an appointment upcoming with the tax collector. In a lot of cases, we are near or co-located with the tax collector. So if you have an upcoming appointment in the next couple of weeks, get your driver's license, march right over to or upstairs here in St. Petersburg and get your homestead app as well. Or at that point, you can go online if it's before March 1st. Any application that comes in after March 1st on our website will automatically be a 2023 application. That's what your receipt will say. But there is a way we can get you qualified for 2022. We prefer you file on time before March 1st, but if you file late, there are other forms you need to fill out. And as long as you own and occupy as of January 1 of 2022, we can see if we can get you qualified. So that concludes our presentation. And happy to answer any questions.
If you have any questions, you can certainly unmute yourself at this point, and we'll be happy to answer any questions you have. All right, again, if you have any additional questions specifically about your property, we do encourage you to give us a call or visit us at one of our locations. Again, our next session will be on March 10th, and we thank you very much for joining us this afternoon, and we look forward to seeing everyone soon.
Thank you all.
Thank you.